Okay. Thank you. Is everybody seated? It's 6 o'clock now, so let's start the meeting. It's the Standards Committee meeting today, Thursday, February the 3rd, and I am your chair, Councillor Yasmin Waheed. Welcome you all. Right, just a couple of housekeeping rules. This meeting will be live streamed to the public. Please ensure you have scanned your QR code poster before entering the meeting. The indication loop is now in operation in this chamber. Right. Any exempt private items on agenda, the live stream will cease prior to the meeting moving into private. There might be a short delay. A recording of the public part of the meeting will be available on the Council's website within 24 hours of the meeting. Attendees are required to wear masks on entry to the building and meeting room, but may remove them when seated. Would all members and officers please remember to switch microphones on when speaking and speak directly into them and switch off when they're finished. Any officers that are called upon by the portfolio holder should address the executive using the microphones marked presenting officer at the rear of the council chamber. And just another reminder, please switch your mobiles off or place them to silent mode. Thank you. Right. So, is there any apologies?
Yes, Chair, we have apologies from Councillors S. Salim and Councillor Young.
Okay. Right. No more? Okay. Scapathon as well. Thank you. Right. Should we move on to item 2, the minutes of the meeting on the 10th of June, 2021. I will go page by page, right? So page 1, okay, are we happy with that? Page 2, page 3, got page 4, and finally page 5. We all happy with that? Agreed? So I could sign that off. Thank you. Okay, so the second minutes we got on the 9th of September 2021, and I'd just like to remind members that this was not correct, and so we need a decision to ratify the decision. So Mark.
Thank you, Chair. Members will recall that only one independent member was present at that meeting, and the quorum for the meeting is 5 members, including at least 2 independent members. So whilst we conducted the business of that meeting, we weren't able to take any effective decisions. And therefore, the Chair is now asking you to ratify the decisions that were taken at that meeting in order to make them effective.
Thank you. I don't think it was agreed on that night that actually it was in court. It's only been seen subsequently in these minutes. So the meeting was held on that night without it being known that quorum wasn't correctly there. I believe the monitoring officer was going away to check on that position.
Yes, nevertheless, it was in quorum. So although we weren't certain at that time, it was in fact in quorum, and therefore we need to ratify the decisions that were taken in order to make them effective.
That wasn't the conclusion reached on the night. That's been subsequently clarified. I just want to say that it wasn't stated on the night that the meeting was in court.
I think I just agreed with that point. I think I said that we were not clear on the night, but that it was subsequently established that it was in quorum, and therefore we need to ratify the decisions that were taken that evening in order to make them effective.
Okay, thank you for the clarification.
We go again, page 6, the first page of the meeting. Is that okay? Page 7.
Yasmin, sorry.
So
So I did give my apologies for that meeting. I had COVID, but it doesn't really say.
it's not been recorded here.
Yeah.
Right.
Sorry,
That's-
sorry, I didn't quite catch this one.
Councillor Ali sent her apologies, but it's not been recorded in the minutes.
Oh,
Apologies, yeah. Is there anything else? Yes.
Hi, I just want to add that I also sent my apologies. They weren't recorded, as did Simon, who's not here. Simon Bullock also came back to say he sent his apologies. So if that could be recorded, that we did. What I would also add is that because we also sent our apologies, it could have been realised before the meeting was held that it wouldn't have been quorum because all of us sent our apologies that we were unable to make it. I don't quite know why they didn't get through, but they didn't.
Okay, I do apologise for that. Now it's recorded. Okay, so we said we should go on page 7. Okay, page 8. And the final page 9. Happy with that? Can I? Yes, Jeff? Yeah, okay, thank you. I can sign that. Yes. Yes, Diane.
I wondered what difference will it make now we're Cllr, because the people that weren't here at the meeting won't know, will they, whether it's the minutes are correct or not? I don't understand.
The people who are here, they will know. Yes, Mark? Okay.
Yes, we're considering the minutes for points of accuracy, and therefore those people who were here at the time can raise any points of accuracy on those minutes.
Right. Item 5. Any urgent business?
Non-chair.
No? Thank you. So that brings us to the reports. Item 6, complaints against members.
Sorry, Chair, I think you missed the disclosure.
Oh, sorry. Any disclosures?
Section 106 and disclosure.
Right.
Obviously, Section 106 is not applicable. Disclosure is up to members.
Yep. Okay. Any disclosures, anything? Okay, none. Right, so back to item number 6, complaints against members. And that's over to, is it Mark?
Yes, Chair, thank you. Members will recall that up until now this has been an oral report made by the monitoring officer. Because of the discussion that took place at the last meeting that highlighted some concern about whether the minutes had recorded, the minutes of the 10th of June had recorded what was said at that meeting accurately in relation to complaints against members, I have decided that from now on this will be a written report. That way we have the record so that we can go back to it if there is any concern about the accuracy of what was said. I also thought it would be useful, as it is the first written report of its kind, to give an update on all of the cases that I've had to deal with since becoming your monitoring officer, and that is attached at Appendix A. There are 2 outstanding cases at the moment, of which one of them is pending a police investigation, and the other, I hope, will be resolved this evening by the local assessment panel that's meeting immediately after this committee meeting. So members will recall that a question was raised about a particular complaint that stemmed from a council meeting back in January 2020. And the concern that was raised by members was about the way that it had been described in the minutes as having been not been investigated because of insufficient evidence. when it was plain to see from the minutes of that council meeting that the members concerned had failed to disclose an interest and had participated in the meeting to the extent, apart from one of them, of voting. The concerns raised by members were echoed in a complaint received the very next day, I think it was, from a member of the public, the same complainant who had raised the original complaint, who unfortunately characterised my colleague, the principal solicitor, as having deliberately misled the committee in terms of that particular statement about insufficient evidence. Now, I don't think that that is what the principal solicitor did or intended to do. I think that he made that statement in good faith. But nevertheless, it was an incorrect statement. The reason that was given to the Ombudsman, who got involved when the complainant complained of the delay that had been taken in dealing with his original complaint, was that the councillors had taken appropriate officer advice about declarations of interest, and in any event, the inclusion of the directors did not make a material difference to the outcome of the decision of the meeting. Well, that is true, but that is not a reason for not conducting an investigation. And in any case, we know that it is a personal responsibility upon members to declare an interest. They cannot rely on officer advice, although members often do take officer advice, and officers need to be careful that that advice is sound and correct. But on this occasion, they took the officer's advice. The officer's advice was incorrect, and as a result, the members did something that they shouldn't have done. But it is true that their involvement in the particular item had no impact on the outcome. Nevertheless, the complainant's original complaint was, I considered, justified, and I therefore advised the Chief Executive that the decision not to investigate the complaint should be reviewed, and as a consequence, the complainant was written to with an apology for the delay, but more so for the complaint, the fact that the complaint was not properly dealt with. I was subsequently questioned as to whether I would be carrying out an investigation into the matter, but it seemed to me that the public interest would not be further served by an investigation. The purpose of an investigation is to confirm what is known or to discover what is not known. And in this particular case, we knew what we knew, and there was nothing else that needed to be known. The fact that the members had participated in that particular item was a matter of public record, so there was nothing to find out. But clearly, the complainant was justified, and therefore, as I say, he was written to with an apology and an acceptance that his original complaint had been justified. So that, I hope, satisfies the concerns that were raised by members of this committee at the last meeting. Thank you, Chair.
Thank you, Mark. Thank you, Mark. Any questions, any comments? Yes.
Yes,
Councillor Chapman.
Thank you. The complainant's been written to. Is he or she happy with that outcome?
He has not responded, Councillor Chapman, and I think he is a gentleman who would make it known, I think, if he were dissatisfied with the response.
Questions or comments?
It's all a little bit vague, but I presume, I think I know what we're talking about, and was concerned, the person concerned was sad that it hadn't been dealt with properly. And at least a caution possibly should have been given to the councillors that didn't declare an interest.
Well, the matter that I refer to, Councillor, I think is well known to you because it's the subject of your email that was sent via Councillor Franks on the 29th of September.
Yeah.
And that was from yourself, Councillor Chapman and Councillor Skeppelhorn.
Yeah.
So that's the matter that I'm referring
Yes.
to.
Okay. Yes. That's
I absolutely agree. It's not enough simply to give an apology to the complainers whose complaint has not been dealt with properly. I have also made it very clear to any member who is a director of one of the council's wholly owned companies that they must unfailingly declare an interest in any matter that affects the financial interests of that company. I have made that patently clear. I made it clear before the training session that took place before one of these meetings, and I've subsequently issued guidance to all members of the council, that was back in October, who sit on any outside bodies where they are expected to declare an interest. So I very much hope this situation will not arise again.
okay. So has Councillor Franks been made aware of it?
Yes, indeed, I responded promptly to Councillor Franks's email of the 29th of September. He is fully aware of the action that has been taken.
Right, okay, thank you.
Yeah, sorry. Can I just, so we're, just for clarification, we've got, for me as a councillor as well, two councillors voted on something at full council. They were directors of the company, and that company was Luton Airport. There would have been a financial cost to Luton Airport had the motion gone through, but the councillors didn't declare an interest. So we're now saying, well, it didn't affect the vote, so we're not going to carry on with the process. That just seems a little odd, because it's kind of, I know you're saying you've told them now, but it has set a precedent that because the vote's not affected, you can nearly vote in a meeting without declaring an interest. So I just thought the process might be that the two councillors could be asked as to why they felt, and that might help clarity for current councillors as well.
Chair, I must say that Councillor Chapman has put a rather strange construction on what I said. I certainly did not suggest that if it doesn't affect the outcome of the meeting, that the members are absolved from disclosing an interest. That is absolutely not the case. As I have just said, a director of one of the council's wholly owned companies must unfailingly declare an interest in any matter that comes before any meeting of this council. Now, I cannot be more emphatic than that. What would we do if we went through the formal process of considering these, the error that the council has made on that occasion? We would tell them not to do it again and to make sure that in future they unfailingly disclosed an interest. Is that not what we would do as a committee? And that's what's been done.
The only thing we would hear is their point of view as to why they chose to actually vote at that meeting. just might help. It's just a thought.
Well, I agree, but that wouldn't make it any more right. They were wrong not to declare an interest. That's the sum total of it. They were wrong.
Thank you, Chair. Yes, I'm a little confused myself. Was there an assessment panel established to look at the decision or the recommendation from the monitoring officer that in fact the matter should be upheld? That's my first question.
I don't believe that there was any action taken by my predecessor to bring the matter to an assessment panel. I think it was a judgment of that my predecessor took.
Thank you. Because if there had been, and indeed this is a matter of process, then if it had been upheld, then the matter would have been looked at by an adjudication panel to consider what sanction, if any, should be applied. And one of the sanctions may well be, to be considered anyway, removal from the position.
As it happened at a meeting of full council, I'm not sure how they could be removed from their positions.
One of the sanctions, I think, which is available certainly, is that a councillor who has been found to have breached the code, which is what we're saying here, can be removed from committees. And it could be argued, therefore, that would also apply to wholly owned companies of this council.
Thank you. Right, any more? Or should we, the committee is recommended to note this report. Do we note this report? Yeah? Okay, thank you. Item number 7, it's LGA Model Code for Conduct. And it's for us to adopt it or not. So.
Thank you, Chair.
Yeah, Mark.
So this time last year, my predecessor brought a report to the committee setting out the fact that the Local Government Association had published a model code of conduct pursuant to the recommendations of the Committee for Standards in Public Life that had been published in January 2019. The committee at that time decided to take no action, but to ask for a review in a year's time. This report, therefore, is in the manner of that review. I've looked at the LGA Model Code of Conduct, and I think it's very estimable. It is very clear. It's very comprehensive, and it provides a great deal of support for members and for members of the public in understanding what the obligations are that are placed upon a councillor and a co-opted member as a consequence of that code being adopted. There's also extensive guidance notes which are available, which help, again, even further to understand the implications. And at the moment, the Lawyers in Local Government has been commissioned by the LGA to produce training packs around the Model Code of Conduct. So there is a lot going for it in terms of support and in terms of making things much easier for people to understand. And you will recall when I recommended to the last meeting of the committee that we adopt some revisions to our own code of conduct, that the section on interests in our present code of conduct I entirely replaced with that from the model code, because I thought it was a great deal more, a great deal easier to understand than the one that we have at the moment. There has been some hesitation amongst local authorities to adopt the model code because a number of the recommendations of the Committee for Standards in Public Life require primary legislation to be put into effect before they can be adopted. Those are mainly amendments to the Localism Act 2011. And some authorities have thought, well, perhaps we should wait until that primary legislation is brought about so that we don't have to make any further adjustments. But how long might that be? And should we really forego the opportunity of adopting something which I think is much better than we've got at the moment in anticipation of primary legislation coming along at some time in the future which might require us to make some changes to it? Well, these things often evolve and require changes, so I don't think that's necessarily a particularly strong argument. So I think it's worth undertaking a consultation exercise, which the committee did ask for at its meeting last February, but which has not taken place to date, to see whether members of the council, independent members, other interested parties think that now is the time for Luton to change from its existing code of conduct to the model code of conduct. And to come back to a future meeting of the committee with the results of that consultation exercise. Thank you, Chair.
Thank you, Mark. Any questions? Yes? Yes, sorry.
I just think on the model new code, there is still an anomaly. So I'm reading from page 17, where it says, in accordance with the public trust placed in me on all occasions, about the general principles. But where it goes down application of the code, this code of conduct applies to you when you're acting in your capacity as a councillor, which may include. So, and I'm thinking back to the situation we had last year where the councillors, where we had adjudication panels, and I think everybody agreed they'd acted improperly, but we couldn't show that they were acting in their capacity as councillors. This code of conduct brings exactly the same position. It appears from my reading of it. So I think I'm not sure if this gives us what we want to do in terms of saying, I'm totally happy with about on all occasions in the Nolan principles. I disagree with the part about when you're acting in your capacity as a councillor. I think the standards that people set are the standards that people should have all of the time, not just in specified capacities.
Yeah, I think there's many people would sympathise with Mr. Orr's view. I certainly do myself. But I think that what is in the code at the moment is consistent with the law as it stands. And I believe that that differentiation between a councillor acting in their public role and in their private role is one of the things that the Committee for Standards in Public Life raised, but would require some change to legislation to bring about. So I would certainly hope to see that happen, but at the moment we are left with that situation, which I think we would all agree is very difficult for people to understand how that differentiation can be made.
Any more questions or comments? Yes, sir.
Yes, thank you, Chair. Yes, you're right, Monitoring Officer. We are bound by case precedent from the High Court in terms of defining the boundary between public and private role, and that is something which as I understand it, yes, only primary legislation can redress that difficulty we've got. Back to the code itself. I know it was subcontracted out to Paul Hoey Associates by the LGA to draw up a model code. I happened to see him about a week or so after he was asked to do it, and he bent my ear on the issue. I note that there is no reference, and there was, I think, in the previous code to the Bribery Act as well, which could well apply. That seems to have disappeared.
Mark, you know anything about that?
Well, I don't think there's a reference in the council's own code of conduct, but there may well have been in a previous version of this model code. Is that what you're saying, John?
I don't know what... yes, I think you're right. I don't think it is in the current code which is adopted by this council, but I think that there are a number of references to the Bribery Act which my members could find themselves having some difficulty with. And I thought it might be useful to look at including it if necessary, because it would alert them to some difficulty they could find themselves in.
I think that would be very helpful. If we can add a little bit more to it, then no harm at all.
Thank you for pointing that out, John, and Mark will look at it. Okay, thank you.
Thank you. Thank you, Chair. Just a general one. In my ignorance, the LGA changing this, lost my train of thought. How often does that happen? Would that be every 3 or 4 years? Do we have a guideline on that one?
I imagine they would have some sort of review process which would reflect the experience of local authorities using it. I haven't been able to ascertain how many authorities have actually adopted it at the moment, but the more that adopt it and use it, the more likely is that issues will be thrown up and there may be a need for review. But I wouldn't have thought it would be the sort of thing that would be reviewed on a regular basis, because the principles won't change. It's only if there is a change in primary legislation that it would need a particularly significant overhaul.
Thank you. Yeah, that was good. My second question was, do we know roughly how many councils are using it? But I would have thought, personally, if you've got a code set for local government, it would be ideal to use that in the sense of, you're following hopefully what is best practice, but with some caveats like the independent members are saying, where we look at other additions to it. And so to go out to consultation would seem the right way.
I'm particularly mindful, Councillor Chapman, at the last meeting you said, well, it would be really nice if in our code of conduct we could have some sort of, some rubric to explain what this actually means. And actually that's what you find in the model code of conduct, which I think makes it much more user-friendly.
Councillor Moe.
Yes, going through it, it's a lot simpler to read. It's superb. Even the layman can understand it a lot better. And with regard to how often we update it, well, I've been a councillor now for 10 years, 10 and a bit years, and I don't think it's ever been changed in those years. I mean, it'd be quite interesting to find how often it has been altered, because I don't think it has. I'm not aware of being at a meeting, a standards meeting.
We did, since I've been appointed, there was a time where it got reviewed. I think some minor amendments got made. John, you'll remember that. So I recall it was reviewed and updated slightly, but not a significant update. I think it was just a few minor things that had come up in assessment panels that we felt should be reflected in the code.
But not to the extent that it is now. No.
I think the last time it was looked at in any depth was 2012, when the Localism Act 2011 came into effect, and of course made significant changes to the standards regime at that time. But the committee decided that it would pretty much maintain the status quo, irrespective of the fact that the framework had been dismantled. apart from that, the only significant changes that have been proposed, and even those are not to the sort of general obligations in the Code of Conduct, were those I brought to you at your last meeting.
Yes, thank you for that.
Yeah, I think that the points that have been made about it changing, when it's changed in the past, I can remember, are significant, because this should be a working document that changes with circumstances and should not be set in stone. So it has to be a document that can be changed and should be changed. Thank you.
Yes, John, thank you.
Yes, thank you, Chair. If the question being asked of this committee is whether to adopt this to recommend it to Council to adopt it, then I would certainly be in favour of it. I think that there is some advantage in not removing anything, because if you do, then you have to justify why you're removing it from what is being presented as the model code. I know one or two authorities in the past have started to tinker around with it and have removed, for example, the disrepute clause. I'm glad to see that it's in there. In my opinion, I'd say they're setting themselves up to have considerable difficulties if they do that sort of thing. So if they follow the model code, as I would certainly support it, then that would seem to me the best way forward. Thank you, Chair.
Thank you, John.
Yeah, just at the moment, obviously the model code doesn't mention things about procedure or sanctions. I think that is in the current code, and it's just making sure that the public are aware of how they can make complaints. I think one of the things as well that was very frustrating when we had that assessment panel with the councillors attending the event is that people didn't realise the limited sanctions that we're able to apply, and it's just, again, it's managing expectation.
Yes, that's a very good point. In actual fact, our own code of conduct was highly unclear as to the procedures that were to be followed until I dealt with it at the last meeting of the committee. And in fact, that was harking back to the complaint that we discussed a little earlier. That was one of the points that was made by the complainant, that the procedure that was actually included in the Constitution in the form of a flowchart was so inadequate that it led to misleading assumptions about how complaints would be investigated. So if you will recall, at the last meeting, I introduced as an appendix to the current code a very exhaustive procedure note which set out exactly how a complaint would go through the process. And I believe it makes reference to the sanctions. If it doesn't, I can't remember off the top of my head, but if it doesn't, I think it's certainly worth putting a paragraph in with those, just to reset the expectations.
Talking about sanctions themselves, I know that there was a part of the consultation included beefing up the sanctions, and that will need primary legislation. So I think that is really why some of the authorities are holding back to see what that is. I don't think we should use that as an excuse, because it could be some time before those are beefed up, but they would include what used to be a sanction of suspension for up to a period. That's right, yes. So I'm entirely with my colleague on that one.
What the recommendation is that the committee is recommended to instruct the monitoring officer to undertake consultation with all members of the council and other interested party as appropriate, with a view of reporting back to a future meeting of the committee on whether or not to recommend to the Constitution Committee to recommend to full council that the current code of conduct at part 9 of the council's constitution be replaced by the LGA model code of conduct. We agreement with that? Yes, Councillor Pence. Yep. Thank you. Oh, so everybody. Okay, thank you. Thank you very much. Access to agenda item number 8, which is the draft standards committee work plan. So, Mark, over to you. We haven't got no dates at the moment, but that's what we need, yes?
Yes, Chair. And I think the dates are now set in the draft calendar of meetings, and they'll be about the same time as they were this year.
Okay.
Probably a day's difference. So around about the 6th of June, around about the 8th of September, and around about the 1st of February, I would have thought. Now, there's not much on the work programme at the moment. For the June meeting, we've got the standard stuff around the Chair's annual report, and the attendance and training record, the whistleblowing annual report. But after that, there isn't that much. But I will try and fill it up, if possible, so that the committee has something worth debating.
John, thank you.
Yes, thank you. Yes, if in fact full council does agree to accept the new model code, then that will need some training, and I think provision needs to be made in the work plan to accommodate that.
That's a very good suggestion, and hopefully by that time the training pack will be available.
Sorry, Chair.
To ask, sorry. Yes, go on,
sorry, Chair.
Councillor
Just
Chapman.
going back to our possible adoption of the LGA, can we put a time frame on it? I'm aware, I know we've had COVID, etc. Do we feel as a committee that we try and get some responses by a certain time so that it can be enacted, or are you happy for it? I don't know. Advice, guidance.
I would certainly aim to get something back to you at your next meeting in June.
Thank you, Mark, for that. I just was looking at the work plan for meeting on June 2022, and it says like annual chair's report and members' attendance training, and it says whistleblowing annual report. Is that, I mean, there's two of the annual reports. Can't one be moved at the bottom, because there's only, but then again there's certain other things that's going to be added on to the agenda on the September one? Or is it time restricting that you have to present the whistleblowing report at this meeting?
I'm not sure whether it's mandatory to take those reports. We'd normally try to get them out of the way as soon as possible after the end of the municipal year.
Okay.
So I think they can stay there, and then we'll find some fun stuff for the subsequent meetings.
Thank you. Thank you for that, Mark. Any other questions? Okay, so that's the end of the meeting.